Good evening and welcome to the 2020 Hillsborough County Charter Review Board meeting for the month of September. At this time, the meeting is officially called to order. And if everyone will please stand or do whatever you need to for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Good evening, members. It's good to see everybody again. Hopefully everybody's been able to stay safe and dry since our last meeting. At this time, I'll turn things over to the clerk of the court to do a roll call attendance.
Good evening, Narain.
Present.
Barry.
Present.
Bryant.
Present.
Dillaverne.
Present.
Fig.
Here.
Fox.
Here.
Johnson.
Present.
Mueller.
Present.
Scarola.
Present.
Shaw.
Present.
Stewart. Stewart.
Oh,
Was that Ms. Stewart?
yes. Can you hear me?
I can hear you now. Thank you. Thrower.
Here.
Wood.
Here.
Yates.
Present.
Thank you. You have a quorum.
Thank you very much, Mr. Clerk. All right, ladies and gentlemen, Mr. Brewer, I'm going to throw it to you to find out if we have any public comment for tonight's meeting.
Good evening, Chair. No, sir, we have received 0 submissions for public comment this evening.
Okay. I don't have the typical statement in front of me, but as you all know, the Charter Review Board does welcome input from the public. We ask that you limit your comments to 3 minutes and that any comments that you have are directed towards the issues at hand and not any individual members of the board. Nonetheless, at the end of this meeting, we will once again call for public comment just in the event that somebody decides to call in or send an email that needs to be read on the record. Thank you very much. All right, we're at the section for the approval of the minutes. Members, have you had a chance to look over the minutes? And are there any concerns? Remember, you can raise your hand through the portal. Okay, seeing none, we'll entertain a motion to approve the minutes from the July 21st meeting.
Motion to approve the minutes, Mr. Chair.
Thank you. We have a motion. Is there a second?
I second. Stacy Yates.
Thank you. We have a motion and a second. Any further discussion? All right. Are you ready for the question? All in favor of approval of the minutes from July 21st, 2020 by sign of aye?
Aye.
Any opposed? All right. Minutes have been approved. All right, ladies and gentlemen, under our old business, a few months ago, it was requested that we have a discussion about the civil service procedures here in Hillsborough County. Everyone should have received the information necessary to have this discussion tonight if we choose to have so. Before we jump into this, I'd like to turn over to our board attorney, Mary Helen Ferris, for just a brief overview of the information that was sent to you in your packets and a discussion of some of the legislative repealer bills that were put in front of the county a couple years ago. Ms. Ferris?
Okay, thank you. The materials that we provided there was some BOCC agenda items with backup. There's a letter signed by the 5 constitutional officers, memorandums from all the other affected agencies saying they agree with the new process, 2 legal opinions. And the repealer bill was effective in October, and it was passed by the House and the Senate with only 2 nays in the House. And the repealer bill requires 2 things, basically a fair, neutral, and impartial system for tenured employees that would be substantially similar to what the Civil Service Act did. And it also requires the 18 agencies to have a uniform process. So the issue really is As you know, the charter can only affect the board, the county attorney, and the county administrator. It does not affect the constitutionals. It does not affect all these other agencies that were included. And so while I understand there was some comment on the new process, the law requires that it be uniform across all the agencies, and the charter cannot affect the constitutionals and all these other agencies. So the Charter Review Board really doesn't have a broad area to work with here, because all you could do is put in the charter what is already in place already by interlocal agreements with all the agencies. So I just wanted to make that clear to everybody.
Thank you, Ms. Ferris. I'm going to open up the floor for any discussion or on this particular item, or any questions that you may have for Ms. Ferris. Again, I'm looking through, so we're using a different system. And if you have your hand raised, I'll have you down. I see Mr. Barak here, but unfortunately, because we're in the portion that's reserved for members to have a discussion, I'm not going to call on you until public comment, but I do see your hand and we'll come back to you. Any members have any questions or comments for Ms. Ferris? Going once.
I raised my hand.
Okay, Ms. Stewart, I see you there. You're recognized.
I just wanted to comment that it was a lot of reading, but when I finally got to the final copy, Mary Helen, that is, I assume, the completion of all the revisions and that the board did finally adopt that. Is that correct?
The board did adopt it, yes.
Okay. Do we know if there have been any actual cases to come through this process as yet?
Actually, I have Jennifer Castro and Ivy Martin from our HR department, and maybe one of them can address the number of cases that have come through.
Good evening, board members. My name is Ivy Martin. Are you able to see me? I'm Ivy Martin, and I'm the Director of Human Resources. To date, we have had 5 appeals that have been filed, 1 that has been resolved, but to date, we have 5, to answer your question.
Okay, so these are appeals to attempts for discipline?
Yes, ma'am. They are appeals for employees who want to appeal the final determination of discipline for either a dismissal, termination, or demotion or suspension.
And did you observe any problems in that process? Has everything worked as you expected it to?
Absolutely. So there's a couple of just key facts that I'd like to share with you, is that we have found that this appeals process has been, 1, more cost effective without sacrificing the employee protections. Under civil service, we had identified that it cost about $89,000 per appeal. And we have streamlined that down to about $7,000 at really a maximum per appeal. As well as it is more timely and time effective for the employee to be able to receive resolution. When I say that there's greater protections for employees, we have shifted the burden of proof from the employee to the employer, so that it's put more onus on us as the employer to be able to have that burden of proof. And then in addition to that, we also surveyed all the other counties within Florida. So out of the 67 counties within Florida, all but 8, and we're included in that 8, they all chose to identify that management is the final decision maker. And we're part of those 8 counties that have identified that we are willing to shift that to a third party through this intake appeals process, so that a third party with labor and employment experience, union experience, qualified individuals who understand the burden of proof and just cause are able to hear this from a neutral party standpoint and make a determination.
Thank you very much, Ms. Martin.
Thank you, Ms. Martin and Ms. Stewart. Any follow-up? Okay. I see Representative Shaw, you're recognized.
Thank you, Mr. Chair. I was going to ask Ms. Martin, she's the HR director for whom, what entity? I missed that.
Yes, Chairman, I am the HR Director for the County Administrator's Office under Bonnie Wise.
With just one follow-up question. It says, I'm reading the materials, it says it'll be a fair, neutral, and impartial process with rotating panels of appeals referees who have labor and employment experience. I know from practicing law that there are two sides of labor and employment. There's employee and employer. Can you tell me, or do you have a sense of where these referees come from? Are they from the employer representing side or the employee representing side?
So that's a really excellent question. So what the county did is we contracted with the American Arbitrators Association, AAA, and we gave them those basic criteria and we allowed them to manage the process. So it does work on a rotational basis so that it does not provide any bias for an arbitrator to decide in favor of the employer or the employee. It's a first come, first serve is how their names are identified on a list. And when we do have an appeal, AAA will contact that arbitrator and say, are you available? If they say yes, they're provided that case, and we have a flat fee structure. If they're not available, it goes to the next person on the list. So it's not like they get more business or they're able to generate any kind of business based upon being a part of this process.
Just one last follow-up, if you will. If of the last 10 cases you have seen, how many of those have been won by the employee?
Well, we've only had one appeal under the current appeals process that has actually come to resolution at this point. So the other 5 are still in process under this process. But under civil service, I don't have those stats, but I'd be happy to come back to the board with those.
I think I would be interested to know the breakdown of how many times the employee was successful, but I appreciate that. Thanks.
Right. Thank you, Mr. Shaw. Mr. Mueller, you're recognized.
Thank you. Just a quick question. I didn't catch, where is the process found? Is it in a personnel handbook or for each of the organizations or what?
If I may, and I'll also ask Jennifer Castro, who is the employee and division director over Talent Solutions. But our policy is identified as part of our policy and procedure manuals. I believe that each organization has integrated those in place of the civil service rules. But employees are provided with that policy and their rights every step of the process, from the point that they're noticed that they're going to a pre-disciplinary hearing to when they're receiving their notice of discipline. And then we also have an entire appeals intake office where they're provided that information and someone can guide them through that process.
All right. Is Ms. Castro on the line? Did she want to add some additional comments to that?
Yes, I am on the line. I would also like to point out that the process when we developed it is very similar, almost identical to the civil service rule laws 11, sections 11 and 12, and also the previous civil service rule 15 and 11.2. Our teams worked very closely to ensure that we had a very similar mirrored process to most of the elements of civil service, with the goal of really streamlining but not taking away any protections. So part of that process has always been, both under civil service and under the new process, that employees get both a pre-disciplinary hearing before they receive discipline, and then the post-review of discipline, which is the appeal process. So during the pre-disciplinary hearing process, as Ivy mentioned, during the hearing, employees are advised of their opportunity to appeal in the process. And then in addition to that, they receive a notice of discipline once a final decision is made after that pre-disciplinary hearing, which also advises where they can find all the information they need about the appeal process, how they can file an appeal when the appeal filing is required. So they are provided that information at several points throughout the process. And if you're interested, I believe in the packet Mary Helen provided, most of the information is available there, but the process is also available on the Hillsborough County website. So all the agencies have a policy that advises about the appeal process, and then in addition, all the documents are on Hillsborough County's website.
Thank you. Mr. Mueller, did you have any follow-up?
No, I think the answer to my question, I think the thing I was looking for is whether the employees, prior to any discipline or anything, would have access to this process. That was my question. So thinking that it might be in a handbook, but it sounds like it's also online, but I was just seeing if it was in a handbook.
Yeah, in the employee handbooks. Yes.
Thank you, Mr. Mueller. Thank you, Ms. Castro and Ms. Martin. Ms. Yates, you have your hand up. You're recognized.
Thank you. This might be for Ms. Martin, and if not, maybe she could point it in the right direction. You mentioned that there were current, like 5 appeals, I think is what you said, pending. And then I'm curious, of those 5, how many are attorney reps?
At this time, the one that we had did not have an attorney that is resolved. However, the other 5, since due to COVID, a lot of them have been delayed, and so they're in the process of being rescheduled. And so we'll find out at the time of scheduling if they are represented. At this time, I don't believe that any of them are currently.
And then you kind of led me into my next question. I was going to ask how the COVID crisis has impacted this scenario.
So it has impacted the scenario, specifically where disciplinary actions as well as the appeals processes have been placed on hold throughout the uptick of the COVID cases. And so we're getting back into the swing of things where we're working with the employee, if they have any representation, their representation, if they should have some, to get those rescheduled and on the books to make them as timely as possible.
So hypothetically, if I was an employee that was demoted during this time, am I just hanging out in that demotion with no kind of recourse or procedure to move forward with that demotion issue? Just hypothetical.
Yes, hypothetically, in that situation, the demotion would be in effect. They would be proceeding with their employment in that demoted capacity, pending the outcome of their appeal, very similar to what occurred with civil service. So that same process is following exactly.
All right. Ms. Yates, any further questions?
Not yet. Thank you.
Okay. Any other members with questions, please raise your hand via the chat. For now, Mr. Mueller, I think your hand is just still up, but I don't see any other questions. I want to thank Ms. Martin and Ms. Castro for being here tonight to answer those for us. Any other questions, members? Okay, seeing none. Ms. Ferris, is there anything else you wanted to add?
I have nothing more. Thank you.
Okay, thank you very much. Members, as you heard in the beginning from Ms. Ferris, there really isn't anything that we can do in this particular situation to address any concerns that you may have.
Point of procedure, Chair.
At this point in time, this is not an issue that is affected by the Hillsborough County Charter. So there isn't anything that we can do because legislative action was taken to repeal this here in the county.
Mr. Noreen, is there an opportunity to offer public comment on this item?
At the end, Mr. Barak.
I'm sorry. My understanding was that I was actually invited to have the opportunity to address the board on this issue. Which is why I didn't do public comment earlier.
I'm sorry. Who'd you receive the invitation from?
Ms. Ferris.
Ms. Ferris, we had a pre-meeting and that was not relayed to me. That's not to say that's not the case. I don't think that's the case.
Mr. Barrick had emailed me for conversation. I've been so tied up with elections and stuff. So I did send him the same materials that I sent the board.
Okay, understood. But out of fairness to all the other citizens in the county, you would have to be reserved to public comment either at the beginning, which you've already missed, or at the end of the meeting here.
I don't. Well, again, don't your rules allow for public comment on individual items that are before the panel?
Yes, at the beginning of the meeting or at the end of the meeting, but not during our actual conversation as reserved for the members of the commission here. So I'm sorry, but we're not going to take any comment at this point in time on this issue. But if there are any members who maybe want to say something, that's perfectly fine. Okay. It doesn't look like we have any other comments from any of the members here. We're going to move on to new business. Does any member have any items for the board? I don't see your hand in the chat if you do. Oh, Ms. Yates, you're recognized.
I'm just going to keep bringing it up every meeting that we'd like to hear from the former county administrator.
The former county, he declined the opportunity to speak to us.
I would just like to ask him again.
Sure, we'll make a note. We'll ask staff to make that request again. Mr. Shaw, I see your hand. You're recognized.
Thank you. Yeah, I had a similar concern. I might be interested if the former administrator doesn't want to talk, at least speak to someone who has a 30,000-foot view of the interplay between the county administrator that we were interested in. If we can't hear from the former one, I understand that that's his prerogative, but I might be interested in hearing from someone who has some historical context about the interplay and how the administrator's office works. That's all.
And we are going to hear from the current county administrator next month here at our meeting. So she is scheduled to join us. But you'd like to have somebody with a historical perspective talk about the office, Mr. Shaw?
Maybe I'll reserve until I hear from her. She might be fine. My concern, as I kind of stated at a prior meeting, is it appears that there is every time there's an emergency, there is a conflict between various agencies and how they interplay and who's in charge of what and what the administrator's in charge of and what he or she is not in charge of. That's what I was kind of interested in. But the new administrator, the current one, may be able to respond to that. So that's fine, I guess.
Okay. And I do believe the county commission's working on trying to resolve that too, because I know they just took away power from the EPG, and the commissioners are making decisions now in emergency situations. But your point is well taken. Okay, Ms. Stewart, I see your hand. You're recognized.
Thank you. To Mr. Shaw, in past charter review boards I have staffed and served on previous ones, we've had representatives from the Florida Association of Counties who seek a former county administrator to speak to us and be available for questions on the duties of the county administrator and how they are affected by statute.
I think that might be a possibility for us. I won't name names, but the husband of one of our former mayors is a recently retired county commissioner that maybe we could reach out to. But I'll put that in the hands of staff as an official request. Any other comments? One thing that I mentioned in the last meeting that I wanted to bring up as a directive for staff, I'm very interested in knowing how other counties handle term limits. Hillsborough County appears to have a loophole in the system that has allowed individuals over the course of the last couple of decades to run from a single member seat back to an at-large seat and back, which I believe, and I think many others believe, circumvents the will of people when it comes to term limits. And I'd like us to take that up as an issue here at a future meeting. So if we could have some information about how other counties have prevented that from occurring and what other counties in our region or similar size looks like, that would be helpful.
Be happy to do that.
Thank you. Members, before we move into public comment, any final thoughts under new business? And I'm using my Apple Pencil if it looks like I'm staring at the screen weirdly to look through. All right, folks, we'll move right along. Under public comment, Mr. Barak, if you're still with us, you're recognized for 3 minutes, sir.
Thank you. My name is Ryan Barrick. I'm a labor and employment lawyer with 22 years experience. I'm board certified in labor and employment law. First, you received inaccurate legal advice from the county attorney's office, and I want to mention that. In fact, you are empowered to amend the charter, and you can do a contingent provision. A number of counties have contingent provisions in their charters to deal with situations exactly like this, where there's a requirement to have other actions occur, the charter's amended, and upon those other things occurring, the provision would then become effective. For example, in South Florida, there's a gun control amendment on the Broward County Charter. So you can do things like that. You can put in a contingent provision in the charter. So it was inaccurate to state that you don't have a role. In fact, you do have a role. I also want to state that one of the key things that you all need to realize is that the civil service systems exist to combat cronyism. That's why they're there. And the AAA and this horrible system that they've put in place does not combat cronyism. In fact, it further encourages cronyism. There has only been, in the 6 months prior to COVID, they had one case that they resolved. And that was resolved in favor of the employer by a arbitrator who is a primarily management employed arbitrator. Chris Schulman is actually the one who resolved that issue. And he issued the one ruling. Civil service averaged approximately one proceeding per month. So you went from a system where you had a number of hearings to, in a 6-month period, only having one. So to the degree that we say, oh, this is more efficient or more effective, that's only because the employees now know that the deck is entirely stacked against them, that they cannot win under this horrible new system. It is, so the fact that the county administrator or that some of these other boards like it, well, of course they do. They don't want anyone looking over their shoulder. They don't want citizens having the opportunity to examine how it is they're treating their employees, which is why this board, which sits outside that system, should step up and consider and have a real discussion. And I apologize. I was under the impression that I was going to be provided with an opportunity to make a presentation to you all this evening, just as if the county administrator were to come in, yes, he's a citizen, but he has knowledge that would be helpful to you all, just as I'm an individual who has knowledge that would be helpful to you on this issue, where you do have a role and you should be able to do things. And it's not accurate to say that you don't have a role. You do. So I would urge you to formally make a motion to allow me to address you in a thoughtful way, as others have had that opportunity, and to allow that a system be enacted that is fair for the employees.
Thank you, Mr. Barak. Mr. Shaw, I see your hand.
Yeah, I would ask, first, let me ask Mr. Barak, you heard the presentation. I want to ask you about 2 points. One, you heard people from the county say that this process is not much different than what existed before. Can you quickly respond to that, and also respond to the cost, where they say it was essentially $89,000 per case and they whittled it down to under $8,000 per case?
Yes, thank you, Mr. Shaw. The first issue, these are absolutely different proceedings. Before, you had a panel of citizens who made the determination, right? So you had a group of people who would be involved in the decision-making process. And some of them had human resources experience and some of them didn't. Some of them were just human beings who were county residents and had insights into what was appropriate and what wasn't. So that's a key difference from my perspective. And there are legal differences with the standard that existed under the prior system and the new system, and it's not as good for the employees. It's just not. With respect to the cost, the old system actually previously had a large infrastructure that was associated with civil service, and civil service used to be the hiring entity for the whole county. So civil service actually had a much larger infrastructure that existed associated with hiring. So you had a director of civil service, you had an assistant director of civil service, you had all this paraphernalia associated with that hiring capacity. Previously, they took away that ability and they were only doing the appeals hearing, but they didn't downsize the staff appropriately when they did that. I would agree that there was too much staff at the old civil service system, but it is inaccurate to state that somehow there's been this giant cost savings. In fact, what's happened is the tasks that were formerly being done by civil service staff are now being done by county HR staff. They're still issuing the notices. They're still doing all those things. It's just before there was a separate body that issued those notices, and now it's being done by county human resource employees. When they talk about the difference, the calculation of difference, it's really they're paying $8,000 to this decision maker. If they had citizens functioning as the decision maker, they wouldn't be paying them anything. So in fact, the actual cost associated with a citizen board that makes the decision would be zero, because those people would be serving with no compensation, just as you serve with no compensation, Mr. Shaw.
Thank you, Mr. Shaw. Does that answer your two questions?
Nope.
Mr. Shaw, we can't hear you.
Sorry. I am serving without compensation, so my technology sometimes is messed up. But I would have had a lot more questions, to be quite candid, if I had not been told that this board had no ability to change. And so I'm just going to candidly say, in light of a conflict here, I would, whatever you think is appropriate, I would like to have Mr. Barak back at another meeting. That's just this one board member's preference.
Thank you. Ms. Yates, I see your hand. You're recognized.
Thank you, sir. I also have a couple of questions too. Specifically, I wanted to see if Mr. Barrett could explain to the board a little bit more where in the charter you believe it gives us the power to do this, so we can all take a look at that. Again, because like Mr. Shaw said, I was kind of under the same impression, so I would like to know where that is, that gives us the power to make these kind of adjustments, or where you would kind of direct us for that.
Sure, let me.
For explaining the contingent provision, I'd like to know what that means and how, or if you can explain it a little bit better to the board, what that means and where you rely on that, because I think that's important for us to know.
Okay.
Not to spot, but
Sure, no, I apologize. One sec here. Hold on one sec. So I believe that the creation of civil service systems is actually contained within the Florida statute. And also, and let me get I apologize, I'm sort of multitasking here. And I believe that there's also portions in the Florida Constitution that deal with the establishment of civil service systems. And again, I put me a little bit on the spot on that. With respect to contingent provisions, I know that there are contingent provisions in other counties' charters. And the example that I use with respect to South Florida, there is a county charter specifically that has a gun control provision, which is a contingent provision. And essentially it says, at such time that we are able to legislate on this issue, this is what our legislation will be on this issue. The problem with the way it exists now is there is no mechanism to bring about change to protect the employees. So we're going to be stuck with the existing system forever, because unless this board acts and puts it on the charter and says, we think this is what the future should hold, there's no way for the 18 other entities to come together and change it. Because you can't, because you don't have another mechanism to do it. The best way to do it is have what is really the biggest employer say, we think this is what it should be. We, the citizens of Hillsborough County, think this is how it is. We're going to treat the people who work for us. This is the fairness that we think they're entitled to. And so it needs to come through this entity. And then those smaller agencies and those electeds can be held to account. If you don't support this, why don't you? And really, in terms of numbers, they have far fewer employees. You guys are the county is the big boy on the block.
Ms. Yates, does that address your two questions?
it does, but I'm also with Mr. Shaw, like had I kind of known this issue, I mean, whether or not anybody agrees, but had I known this, I think I would have had more specific questions too.
Okay, we'll circle back around. Mr. Johnson, you're recognized.
Thank you, Mr. Chair. I just wanted to be able to, and I didn't know if Mr. Shaw was going to be making any kind of motion to be able to try and bring Mr. Barrick back at some future meeting. I just want to be able to make sure that if that is the case, that we have the opportunity to be able to bring somebody else from the county to be able to discuss this. That would provide a little bit more of a balance to some of the things that Mr. Barrick might be speaking right now. So I just wanted to be able to have that as an option at some point.
Okay. Ms. Stewart, you are recognized.
Thank you, Mr. Chairman. Mr. Barrick, do you know how Pinellas County manages their employment board? Do they do some sort of an administrative procedure?
So Pinellas County has a civil service board made up of citizens of Pinellas County who hear employee appeals and make determinations, much like what Hillsborough County used to have. But they have a board of private citizens who hear those cases.
But don't they have a unified personnel board?
They do. So it's called the Unified Personnel System, and it's a civil service system. Yes, ma'am.
So how is it authorized? Do you know, is it in charter or is it in an administrative order that they have crafted? I'd be interested in knowing that.
I don't know off the top of my head the history. I could certainly, again, if I'm invited back, I would be happy to discuss the legislative basis for the Pinellas County civil service system, which again is called the Unified Personnel Board.
Any follow-up questions, Ms. Stewart?
No, thank you.
Okay. Is there a motion? Mr. Shaw, I see your hand.
Yeah, if it's appropriate, Mr. Chair, I will make a motion to have Mr. Barak come back and address us. And to Mr. Johnson's concern, I would certainly want the same amount of time, I guess, given to the county to discuss how they feel about the current situation as we give to Mr. Barak to address us on the same agenda.
Okay, we have a motion, and if I understand your motion correctly, and stop me if I'm wrong, to have Mr. Barak come back to the next meeting and give a presentation, but also have someone from the county to balance out the county's position on this issue.
Correct.
Thank you. Is there a second to Mr. Shaw's motion?
I'll second that motion, Mr. Chair.
All right. You have a motion that's been properly seconded. Any discussion on the motion? Well, any further discussion, I should say. All right, are we ready for the vote? We're going to do this by roll call vote, and we'll turn it over to the clerk.
Narrain?
Yes.
Barry?
Yes.
Bryant?
Yes.
De Laverne?
Yes.
Fig? Fig? I'll come back. Fox?
Yes.
Johnson?
Yes.
Mueller?
Yes.
Scarola? No. Shaw?
Yes.
Stewart?
Yes.
Thrower?
Yes.
That was a yes, correct?
Yes.
Thank you. Wood?
No.
Yates?
Yes.
And one more time. Did we lose Fig?
Yes.
We did lose Fig?
Yes, she dropped off.
Okay, thank you. Motion carried 11-2. Members Scarola and Wood voted no.
All right. Thank you very much, Mr. Clerk. Okay, so we have a couple items for the next meeting that staff will come back to us with, and I'll ask you, Mr. Barak, to please seek out Ms. Cardenas and Ms. Ferris to work on the agenda for the next meeting. All right, members, we've had an opportunity to go over this issue and the next. I don't see any hands. So if all hearts and minds are clear, we will consider this meeting adjourned. Thank you all for your time tonight. Bye-bye.
Thank you.